Halo rekan-rekan semua, apa kabar? Saya Yuda Triaryanto, salah satu partner SAP Law Firm yang akan menjadi host SIP Talk kali ini. Episode ini sangat spesial karena kita lagi ada di Melbourne, Australia, dan kita juga ditemani special guest. Dia adalah seorang senior lawyer yang sudah puluhan tahun berpraktik jadi seorang barrister di Australia. Dan dia juga merupakan foreign counsel SAP Law Firm yang biasa membantu kami untuk menyediakan layanan jasa hukum di Australia bagi klien-klien kami. Here with us, Mr. Robert Heath. How are you today, Mr.?
I'm very well, thank you. Selamat sore.
Oh, okay, selamat sore. Thank you. You speak bahasa too. Okay, I extend my gratitude for the warm welcoming us. This is an honor for us to welcome us in this Melbourne and this office. And Mr. Heath also foreign counsel of SIP Law Firm, and we are very happy to having him with us because he can assist us in provide legal services in Australia for our clients. Okay, so Mr. Heath, today we are going to discuss about relationship between Indonesia and Australia, especially in economic partnership. So the first one, before we going to that matters, how do you perceive Indonesia as an Australian citizen?
It's a very good question, a very big question.
Okay.
We know where Indonesia is, but we don't know enough about how diverse Indonesia is and how rich the culture is in Indonesia, how many different parts of Indonesia there are. Often we have a holiday in Bali for 7 days and then we go home. We like it, but we don't know that there's a lot more about Indonesia to learn. And I think it's exciting to know that there's a lot more to learn.
Yeah, I think you have to stay more days in
Yes.
Indonesia to get to know about Indonesia.
Yes.
Okay, Mr. Heath, before we discuss the Indonesia-Australian Economic Partnership, could you share your perspective on the ties that exist between Australia and Indonesia and how this connection may influence the broader economic relationship?
Yes. Well, I think for a long time we didn't do enough together. And then I think it was about 31 August 2018, President Joko Widodo and the Prime Minister of Australia at the time, Scott Morrison, signed the Economic Partnership Agreement at Bogor Palace.
Okay.
And I think that has been a big game changer for how Australia and Indonesia can start to work together more and more.
Because since that agreement, we see that the data, the average monthly export value between Indonesia and Australia has increased significantly. And how do you see this in your perspective as a legal practitioner?
It's a very good question, and I had to think about it, and then the answer came to me very quickly. In my practice as a barrister in Melbourne and in Australia, I have seen the flow-on effects. So there are property developers in Melbourne who are developing more properties to cater for Indonesian students coming to study at Australian universities. And when I go back to the text of the IA-CEPA, the Australian university sector has been opened up for Indonesian students.
Okay.
So I'm seeing the impact of more Indonesian students here upon the local economy.
Okay, so as an Australian legal expert, from a legal standpoint, how has IA-CEPA contribute to providing legal certainty and predictability for business engaging in cross-border trade between Indonesia and Australia?
No, it's changed the tariff issue fairly considerably. So there's been a reduction in tariffs, which is a good thing for opening up investment certainty and business certainty. When people are in Indonesia want to sell goods into Australia, they know how much tax or tariffs they're going to have to pay, and the same applies the other way around. But the other very interesting thing about this agreement is the strategic partnerships and the skill sharing elements. So we want to talk with you about how we can help you with our services, professional people and the services that we can provide. And also we want to hear about the services that you might be able to help us with in Australia.
Okay, so in your experience here, since the implementation of IA-CEPA, have the legal practice and procedure in Australia undergone any significant change?
I think it's still very early days. I think that work is going to flow through more and more when businesses understand that they can do more business with Indonesia and how much of a big market it is, how much of a great economic opportunity it is. Instead of looking over the top to Europe or England or Malaysia or Singapore, realising that there is a huge marketplace on the doorstep of Australia, next door to Australia. And I think as time goes on and people understand the sheer magnitude of that opportunity and how easy it is now to do business with Indonesia because of this agreement, we're going to see more legal work generated as a result.
Okay, so have there been any challenge or adjustment in regulatory compliance in Australia, particularly in response to the legal stipulation within IA-CEPA?
I don't think so. I think really it's a question of letting people know that this new framework exists and that they should take up the opportunity that it presents. I think as time goes on, there will be some challenges and some wrinkles, but nothing people in Indonesia and Australia working together cannot solve.
Okay, so nice. So we note that in the first semester of 2022, Indonesia non-oil and gas export to Australia total substantial $1.6 billion. So expanding the horizon to cover January through August 2022, Indonesia export to Australia reached approximately $2.3 billion. And Mr. Robert, as a legal practitioner, maybe you can share with us a little bit about what exactly the requirements from Indonesian entrepreneurs if they're willing to export their products to Australia.
It's a very good question. It's one that takes a little bit of digging into, but let me just tackle it in a very broad way. So in order to take advantage of the tariff rate quotas and the automatic import permits, it's necessary to comply with the requirements of the scheme. I won't go into that in great detail now because it's all laid out in the text, but there are some product-specific rules of origins for goods containing inputs from outside of Indonesia or Australia. There are some tariff classification rules. There are various things that an importer and an exporter must do in order to take advantage of this new economic agreement between the two nations. And I think declarations of origin, certificates of origin, record keeping, these are all things that a firm such as yours, SIP Law, can help with and will be able to help with.
Yes.
And also things that lawyers in Australia like me should be able to help with as well.
Okay, well, so in your perspective, what is the key aspects should entrepreneurs from Indonesia be aware, or maybe entrepreneurs in Australia be aware, since we have this agreement between Indonesia and Australia?
Record keeping and clean documentation.
Okay.
Know what you have to do in order to take advantage of the agreement. There are some generous elements to the agreement for those who comply with the requirements. And if you need help with understanding the requirements, come and see lawyers who are skilled in that area, who can help provide advice about the record keeping requirements and the different declarations that are required, the different verification processes that are required. In lots of things in this space, attention to detail is so important. You don't want to find that you've committed a lot of time, energy and money to a new investment venture and then find out that it didn't go so well because you haven't followed the rules. So the rules are there, it's all laid out clearly, but I think sometimes the prudent, clever business people in Australia and Indonesia will engage skillful lawyers to help them ensure that the record keeping requirements are complied with.
Okay, so the key aspect is to keep the clean record there.
Know what you have to do and keep the records that are required.
Okay, because the legal aspect is the most important, because if you go to invest and then you break the law, it's nothing, right?
Yes, maybe you're in trouble, but maybe you can't take advantage of the benefits of the scheme if you don't keep the records that you need to keep to establish your entitlement to share in the benefits.
Okay. So, talking about the legal system, we in Indonesia we have Badan Arbitration Nasional Indonesia or BANI.
Yes.
And we understand that in Australia, there's also Australian Center for International Commercial Arbitration. And can you explain more about the ACICA?
Yes, of course. ACICA started in the 1980s and is a very successful arbitration institution in Australia. It's the main arbitration institution in Australia, and it had a huge boost from the mid-80s and then beyond, again around the late 2000s, when the laws changed in Australia to bring Australian arbitration laws into line with the UNCITRAL model law. And since then, ACICA has gone from strength to strength. It has, in about 40% of its cases, a cross-border element or international parties. In terms of domestic arbitration, it often has a joint venture entity or entities that are Australian entities, but they have foreign investors. So behind the Australian company are foreign companies. So it often has that foreign element. It specialises in providing arbitration services for very large domestic infrastructure disputes. That's where it does a great job year after year, case after case. Road disputes, hospital construction disputes, energy disputes, huge building disputes. It does a very good job. There are some very skillful arbitrators. And of course, ACICA, led by the very talented Deborah Tompkinson, does an excellent job in administering cases that are with ACICA.
Okay, so I think you have to explain to us why ACICA is one of the best alternative dispute resolution in Australia.
Yes, I think it has very high quality arbitrators, first and foremost. People who are very experienced in arbitration, people who understand that in order to facilitate commerce and to promote commerce, you need to have a cost-effective, efficient dispute resolution system. So these are very careful, skillful, prudent lawyers in Australia who practice as arbitrators, many of whom have significant experience in international arbitrations and who are very good at helping parties resolve their disputes cost efficiently and fairly.
Wow, fairly.
And so it has a very good reputation.
Most important, fairly.
Indeed. Fairness is critical, but business people, when they're running businesses, say exporting goods to Indonesia or importing goods, they don't want to be caught up in a dispute that takes 2-3 years. The longer the dispute is there, the more money they spend, and it's destructive. It's not constructive. It doesn't help them make money in their business. So organisations like ACICA are very good at making sure that the right arbitrators are appointed to the case and the disputes are resolved fairly and efficiently.
Okay. So, as long as you're experienced, are there any notable success story or case where your case in ACICA?
Yes, ACICA has done a very good job in resolving huge infrastructure disputes, and I know for a fact that there were a series of ACICA arbitrations in relation to a series of disputes concerning the construction of the new Royal Adelaide Hospital, one of the largest hospital infrastructure projects in Australia, if not the wider area, for a long time. And I know that ACICA and the ACICA appointed arbitrators did a very good job at resolving those very complex disputes.
Okay. Are there challenges or considerations that patrons should be aware of when seeking to enforce ACICA awards in Australia?
No, it's the same set of rules that applies to enforcing awards in other jurisdictions. Very limited grounds of for the purposes of inviting a court to set aside an award, and that works quite well. So if someone is in Indonesia and understands how the model law system works, the same system applies here. The one thing I would note about Australian court supervision of Australian seated arbitrations is this. Australian judges, by and large, are excellent in terms of dealing with the enforcement stage of arbitrations in Australian courts. So if a party presents an award to an Australian court, they can rest assured that by and large the judge handling the case is experienced with arbitration. In most cases, the judge dealing with the court case, the enforcement case, has often been in a former life professionally an ACIPA arbitrator.
Okay. So, what do you foresee as potential future trends in arbitration there, and how might these trends influence patrons' decision to choose ACIPA for dispute resolution?
There's a big push within ACIPA to ensure that disputes are dealt with cost efficiently. And in the past in Australia, a generation, 2 generations ago, arbitrations became very expensive to run, and they often mirrored litigation. And now ACIPA is very keen on having its arbitrators understand the significance of ensuring that arbitrations are conducted cost efficiently. And I think that's a huge thing in terms of people choosing ACIPA as an institution. Also, ACIPA is very good at maintaining a diverse and talented panel of arbitrators, and they strive to ensure that the panel is diverse and there are plenty of choices, and each person available for appointment is competent and able to do the job. And I think that ACIPA is looking forward to putting some Indonesian people, qualified people, on its panel, so as to create diversity and also forge closer ties with Indonesian parties.
Okay, Mr. Robert, I think this is the last question for you, and I think our conversation has provided a comprehensive overview, and thanks again for providing your busy time for us.
Summer.
Thank you, and I think such privilege for us to discuss it with you as an expert legal and also our foreign counsel.
It's a pleasure to have you visit me in Australia and host you here, and I look forward to working with you into the future.
Yeah, thank you. And also we are waiting you to come visit Indonesia also.
I would like to do that.
Oke. Baik, rekan-rekan semua, itu tadi diskusi kita dengan Mr. Robert Heath as our foreign counsel, and semoga episode Sipto kali ini dapat memberi banyak manfaat untuk para rekan-rekan semua. Oke, jangan lupa untuk follow Instagram SCP Law Firm dan juga follow, like, and share YouTube SCP Law Firm. Sampai ketemu lagi, rekan-rekan.